Welcome and thank you for joining me for Tax Break. This is a podcast about South African tax for South African tax professionals and practitioners. My name is Pieter van der Swan, and in each episode I share my thoughts on a topic or a recent development in the field of South African tax with you. And I try to keep the episode short enough that you can listen to them while you take a break from work or maybe while you're training or running. Right, the topic for this episode and the previous one is the conduit principle that applies to the taxation of trusts, or as some people also refer to it, the flow-through principle. Now, in the first episode, the previous one, I looked at a recent amendment to Section 25B that basically affects distribution or vesting of trust income by trusts to non-resident beneficiaries. And in this episode, I'm going to look at the application of the conduit principle in the context of capital gains tax, and specifically a recent ruling in this regard by the Constitutional Court in the Thistle Trust case. Right, so just a quick recap again. I did mention it in the previous episode as well, but I think let's just quickly speak about it again. What exactly is the conduit principle? So it's something that was established in the Armstrong case in 1938, confirmed by the Rosen case in the appeal court a few years later, and that was legislated into Section 25B of the Income Tax Act in the early 1990s. And it essentially says that if a trust's income or an amount from a trust vests in a beneficiary, the beneficiary will be liable for tax on that amount, and the amount retains its nature. Now, when we talk about capital gains tax, we find that within the 8th schedule that deals with capital gains tax, there's a specific provision, paragraph 80, that contains the rules on how capital gains tax would work in the context of a trust. And the way in which this rule is worded, it's argued that it only allows for the gain to flow through a trust one level below the trust where the disposal occurred. So let's have a quick look and see why. So firstly, a trust is considered to be a person. If you look at the Section 1 definition of a person in the Income Tax Act, a trust is listed as a person. And if the trust sells an asset, the default position under the 8th schedule would be that this person is then liable for tax, the capital gains tax, on any capital gain arising from the disposal of its assets. So the default position would be the trust is liable for the tax. But then the remainder of section or paragraph 80, it varies this principle a bit. So paragraph 80, subparagraph 1 applies where the disposal is the vesting of an asset by the trust in a beneficiary. And paragraph 82, this is now the one that I think we're going to focus on, deals with the situation where an amount derived from a capital gain is vested in a beneficiary. So what this provision says is where the trust determines a capital gain in respect of a disposal by that trust, the beneficiary obtains a vested right to an amount from this capital gain. What the rule then says is that the beneficiary, the trust can disregard the capital gain, and the beneficiary must take the capital gain into account. The reasoning as to why the wording, or why it suggested that the gain only passes down one level, so from the trust to the next level, to the first level of beneficiaries, is that you need the disposal in the trust itself, and the gain arising from that disposal must vest in a beneficiary. If you look at the next level of, let's say you've got a tiered structure of discretionary trusts, the next trust in that structure wouldn't have a disposal from which it makes a capital gain. So if you look at the wording of paragraph 82, the wording, you don't trigger the requirements, or you don't satisfy the requirements to pass it down to the next level of beneficiary. Right, so then to get to the Thistle dispute that went all the way up to the Constitutional Court, what the court described the structure as follows. It was a tiered trust structure where we had the Thistle Trust that was a beneficiary of 10 vesting trusts. So unfortunately, what's not clear from the different judgments is exactly what were the terms of these vesting trusts. I would suspect that it doesn't mean that the assets of the trust vested in the beneficiaries. Otherwise, this, in my view, the answer would have been a bit different. But probably that the capital of the trust vested in the beneficiaries. Now, but I'm only guessing. It's not something we can see from the judgment itself. The Thistle Trust was then a beneficiary of these vesting trusts, and the vesting trusts disposed of assets vested the gain in the Thistle Trust, which was a discretionary trust, which in turn vested the gain in its beneficiaries. Also important perhaps to understand the dispute then, at the time Section 25B didn't explicitly exclude amounts of a capital nature. So it spoke about the taxation of trusts, and it basically specified how amounts that accrue to a trustee would be deemed to accrue to beneficiaries. Right, so Sarge argued that, as I've explained, paragraph 82 would apply and the gain would stop at the Thistle Trust. So in other words, there was the main vesting trust that vested the gain into the Thistle Trust, and Sarge's interpretation was that that's where the gain would then stop if you apply paragraph 82 or 80 sub 2. The taxpayer argued that the provision of Section 25B would apply and that the conduit principle would apply all the way down to basically flow the capital gains to the ultimate beneficiary in who it was vested. So it's an interesting judgment if you look at the Constitutional Court judgment, and it goes into quite a bit of detail on the conduit principle. It talks about how the conduit principle was established, what its purpose was. It also indicates that the 8th schedule is more than just a schedule that quantifies the tax. So if you look at the overall structure of how it works, it does actually also determine where the capital gain goes. And it focused on the wording of paragraph 82 quite a bit to say that the wording specifically talks about a gain determined on a disposal of an asset by a trust. So basically confirming the view that the gain that we're looking at must arise in a trust because of a disposal by that trust, and then it can flow one level down if it's vested in a beneficiary. And the court basically looked at in confirming that this is the view. They looked at a legislative amendment in 2008 where the wording was of paragraph 80 sub 2 was clarified to make it very specific that it's not just a capital gain, it must be a capital gain from the disposal of an asset by the trust. So the court ruled that the capital gain was taxable in the Thistle Trust. And I think that from a practical perspective, what it then confirms for us is that the capital gains provisions, paragraph 82, if you have a disposal in a trust, that the capital gain from that disposal can flow one level down. And that is the effect of paragraph 82. It can't flow through multi-tiered discretionary trusts. I do think if we're looking at trusts where beneficiaries have vested rights in the assets, the answer would look slightly different, but that's a topic for a different day. Right, so I think to close off, probably since the amendment to Section 25B, it's a lot less debatable whether the conduit principle would apply and whether 25b or paragraph 82 would have applied. But the ruling in the Thistle case is a reminder that in the context of trusts and disposing of assets, it's important to establish what was disposed of and who disposed of it. And I think if you start looking at those questions, as I mentioned, where the beneficiaries have a vested right, a vested interest in the assets of a trust, you'll start picking up where the who actually makes the disposal and where the rules could become quite complicated again. Right, that's it for today. If you like the podcast, please subscribe on your favorite podcast platform and tell your friends and colleagues about it. If you've got feedback or any suggestions for future topics, please send me an email. My email address is in the show notes. And as always, nothing in this episode was intended to be tax advice or a replacement for tax advice. Until next time, goodbye.